With these few words, I request Dipesh to introduce Ajay.
Good evening, friends. Shri Ajay R. Singh, advocate by profession, has completed LLB, LLM from Mumbai University, has completed Masters in Constitutional Law, joined the bar in August 2000. He is practicing as a counsel before Supreme Court, High Court, Income Tax Appellate Tribunal, Settlement Commission, and before Commissioner Appeals. He practices in areas of international taxation, domestic tax, search and survey, advising clients on direct tax issues, and specializes in drafting and appearing in writ petitions and appeals before High Court and SLP before Supreme Court. He has filed various public interest litigations on topics like National Tax Tribunal petition, with benefit tax audit report petition. He has written articles, papers for various journals, including Income Tax Review, EIFTP Journal, BCA Journal, and www.idt.org. He has co-authored books on taxation and allied laws, delivered lectures, and presented papers for various institutions like Chambers, IFTP, and ICAI. With this brief introduction, I welcome Shri Ajay Singh.
As a token of love and affection, I think I shall give this moment to Ajay.
A very good evening to all of you. The topic chosen for the day is very adapt to the present situation. We all are flooded with filing of appeals and assessment orders we have received. The topic chosen for the day is very adapt to the present situation. I have already circulated my notes. The notes seems to be very exhaustive, but it is because of the content and the case law. And one important reason is that when I came to chamber for the first time, I delivered lecture on this very topic. At that time, I had prepared this whole structure. So subsequently only I had to do the editing and adding more and more to that. By this, it became so lengthy. So it is always said that whatever you do when you are at the very beginning, it remains with you and it is always an added advantage. Many procedural aspects also is incorporated in this. I will be dealing with the crucial, important, controversial topics and something which I feel like I should guide in the sense of while drafting your appeals, and some technicalities for which at the later stage of the proceedings many times it affects our matter. So at any stage, if you have any query, please raise your query. It will be interesting to have an interactive session by which we will be able to deal with the important issues involved in this whole appellate proceedings, because we have to deal with two stages, the first appeal as well as the second appeal. Friends, going with the topic, when we are in appeal, we have to always keep our mind and start thinking like a lawyer, where we have to see the pros, cons, what will be our defense, what will be controverted, what is Evidence Act. If we are having an issue of HUF, then we have to understand the Hindu law. If we are having some other property issues, we have to understand the property law, and we should not take the judgments on the face of it, what we read the head notes and accept it. So we have to have some basic knowledge of other laws apart from Income Tax Act also. At the same time, we should also keep in mind the technicalities many times involved in small things like service of notice, when it has been served, how it has been served, whether it is proper or not, dates which are mentioned, replies which have been given, principle of natural justice have been complied with it, whether opportunity of cross-examination has been given. So these small points which is there, which ultimately leads at the end where how your matter is going to take turn. So these small finer points has to be kept in mind when we are drafting our appeal at the first appellate stage, because that is the stage where you build your appeal which ultimately can lead you to success. We have seen many times at the appellate level before the ITAT or before the High Court, the matter is succeeded on these types of technicality, these types of ground, where the department fails to give you an opportunity of process, the department fails to give you the copy of the document which is seized. So these are the points which is very crucial, which we have to understand while drafting and filing our appeal at the first appellate stage. Going with the first appeal which is filed under 246A, as it is mentioned that right to file an appeal is a creature of statute. So we cannot have a right to file an appeal against each and every order. Whatever is mentioned under section 246A, capital A, those are the orders which are appealable. Over a period of time, various sections has been allowed direct appeal, like 12 AA rejection of our registration with the charity, that has been direct appeal has been provided by Finance Act 2015. 1023C appeal has now been provided directly with ITAT. So these are the orders which are appealable, and only those orders can be filed. Orders like 264, no appeal has been provided, so we cannot file. There is one controversial decision which is there of Mumbai Tribunal, that we can file an appeal against 264. I will deal with it separately. Yes, sir.
Sir, if the stay order has been passed by the ITO or by the AO and the amount fixed is too high, the Honorable Commissioner refuses to...
Sir, can I take that when I will come? There is some portion on the stay also I will deal with.
Whether that order is appealable?
No, that order is not appealable, but there is some change in some situation. I will come to that. I will deal with that. So these are the orders which are file appeal. Now the question arises that who can file an appeal? Obviously an SSC can file an appeal, but there are some peculiar situations where a third party can also file an appeal. For example, in a case of a person who has an SSC who is no more, who can file an appeal? The legal representatives of that SSC can file an appeal. In case of a firm, there is a dispute between the partners. The order has been served, one of the partner receives, the other partner is not cooperating. Can the other partner file an appeal? Answer is yes, he can file an appeal. Because filing an appeal is directly related to assessment, the tax. If a tax can be recovered from Mr. X in respect of an assessment made, then yes, Mr. X has a right to challenge that. And the manner in which he can challenge is challenging the concerned order through which the demand has been raised. There are few situations and where the courts have taken that, where an order, the result of an order is that a liability has been created on any person. That person has a right to file an appeal. Situation which I gave you in the case of a legal hire, in the case of a company which is under liquidation, directors are there, one of the directors has been served with a recovery notice and thereafter he applies and gets an order. Can he file an appeal? Yes, he can file an appeal. I have already said in the case of a partnership firm, in case of a legal hire. So these are the few situations where the appeal can also be filed by a third party.
So in case of liquidated company,
Yes.
company under liquidation,
Yes.
who has to file?
The liquidator, originally the liquidator is liable under 160, the liquidator is liable, but there are many instances which will come to know that the liquidator are not filing the appeal. The reason being the order is not served on the liquidator. The process is that whenever a company is in liquidation, we have to intimate to the assessing officer, and the assessing officer has to make the liquidator a party. Because the SSC no more, the liquidator has to be served with the order, but if it is not done or the liquidator fails in performing his duty, it is the other directors, if they are aware, they should try to pursue them, because ultimately the liability will be created on the company. So they can file an appeal stating that the liquidator has failed to take any action and therefore we have filed the appeal.
Usually liquidator doesn't take any action.
Yeah, therefore I said that usually they don't take an action. Then the second is that once the director is there, they can file an appeal on behalf of the liquidator, and they can mention in the grounds or in the statement of fact that this is the circumstances under which the appeal has to. They should make a liquidator a party to that. They should make a liquidator. They should bring this fact to the knowledge of the concerned CIT appeals while filing the appeal itself, that the company is under liquidation, so that the notices at the time of hearing can be served on both the parties, the SSC as well as the liquidator.
Sir, can any trustee file an appeal on behalf of the beneficiary?
Can a
Trustee file an appeal
In cases, yes, in cases where the beneficiaries are not available, or the beneficiary are not able to file an appeal, the trustees can file an appeal on behalf of the beneficiary. If they have been given the rights to file an appeal, or you can create a situation where the beneficiaries are not available or they are abroad. Many times this situation is the beneficiaries are abroad. In that situation, the trustee on behalf of the beneficiary can file an appeal.
If the beneficiaries are minors.
Then certainly, in the case of a minor, certainly the appeal will be filed by the guardian, or first their parents, or by the legal guardian. With this, I have listed down on page 4 some of the instances in which these types of situation arises. At the same time, I have given some case laws also concerning that particular situation. One interesting point is that whether protective assessments are made. Many times this question arises, there is a substantive assessment and there is a protective assessment. What to do? We have filed an appeal against the substantive order, assessment order. Should we file an appeal against the protective? Answer is yes, we should file an appeal, because you don't know at the appellate stage the matter may turn around and the protective assessment can be made as a substantive assessment. Apart from there will be other grounds on the basis of which you can challenge that why even the protective assessment should not be made in your hands. Normally this situation arises in cases of search or survey. Some document has been found, it is alleged that the documents belongs to you, and therefore that addition has been made. So in challenging the merits of the matter, at the same time you can also challenge the jurisdiction to assess me. I am not liable, that document is not pertaining to me, and other issues also. So therefore a protective assessment should also be challenged. As I said that 264 order is not, appeal is not maintainable. Recently there is a decision of Mumbai ITAT of Gosia Cold Storage Private Limited, where the ITAT had entertained an appeal against the order passed by the CIT under section 264. This order is there, but principally I am not agreeing with this order. The section of the provisions of Act is very clear. The order of 264 is final. It cannot be challenged before there is no appeal provision provided for challenging that order. The only remedy against 264 order is to file a writ before the High Court. This order is there. I really doubt the order, this particular order, legally whether it will be ultimately sustained or not. But as of today, there is this order. But you should not rely too much on this particular order. Also, in the context to 264, assume that an order is passed by the Commissioner under section 264 and some directions are issued by the either giving the relief or restricting the relief or denying the relief. In that situation, the assessing officer will pass an order giving effect to the order of the Commissioner under 264. Can this order giving effect be subject matter of an appeal? According to me, the answer is yes. However, recently there is a decision of Punjab and Haryana High Court. It is not referred in my notes. 266 ITR page 158, wherein it has been said that an order giving effect by a commissioner of a commissioner under 264 is not an appealable order. However, facts of that decision was that that particular order was merely an order giving effect, whereas there might be a situation in 264 that the Commissioner directs the assessing officer to consider a claim in a particular manner, verify that claim, and thereafter allow that particular thing. In that situation, if there is some infirmity in the order while following the direction of the Commissioner under 264, in that situation, according to me, the appeal is liable to be filed against to the higher authority. The reason being very simple, what is appealable? The order of the assessing officer and not the order of the commissioner under section 264. Yes, we cannot challenge by indirect route the order of the commissioner under 264. If you are filing an appeal against by an order giving effect and there you challenge something what the commissioner had decided, then certainly it will not lie. But yes, what the assessing officer has done while passing an order giving effect, that is subject to appeal, and one can rely on a decision of Amritsar 76 DTR 36, which is referred in my note.
This will be in tribunal.
This is of a tribunal decision, and the decision.
This appeal will be filed in the tribunal.
No, that will be filed before the CIT appeals.
Before CIT.
Before the CIT appeals. Now we come to the next stage. I have seen one caution, just I will like to make, that I have seen that many times orders have received by the chartered accountants. The order is dated 31st March or 30th March. The order is brought at the after 10th April, and when we say when you had received the order, that actually we have received the order now, but I have already signed on backdated and so and so. It is very dangerous, because the time limit for filing the appeal is 30 days. So if an order you have signed and accepted before the assessing officer as on 31st March, and you have actually received somewhere in 10th April, so really you get only 20 days time for filing the appeal, or 20 or lesser than. So that is a very dangerous, yes, that is a very dangerous situation. Also many times I have seen that where there is, after the assessment order is passed, huge additions are made. Thereafter many times the SSC change the chartered accountant. In such a situation, they just merely come and they put an allegation. So if you are accepting an order on behalf of your SSC, be cautious. Allow the SSC to come and accept it. Allow the SSC to sign it. Before signing or accepting this type of stand, you should have a caution, unless you have too much faith on your client. Just this is a caution. Yes, sir. Some query.
But the SSC has migrated.
Yeah.
And the SSC asked local PA to send a request letter that by case will be transferred to the other.
Yes.
Now no LA was submitted. And ex parte order was sent to CA with the CA refused.
As you said, that first is that the PAN has been migrated. So the migration of PAN happens on certain application which is filed by the SSC or by his concerned chartered accountant, on which the department must have acted, and thereafter it will migrate. It will not migrate automatically. So this is within the knowledge of the department. Now coming to this fact of migration, you have intimated through a ex person who has not filed any authority, or he doesn't have the authority to file. So at the most it is just an information which is given. Thereafter, that doesn't mean that the assessment order has to be served. The assessment order will have to be served on the concerned SSC, which is on the record of the assessing officer, in respect of whom he passes an assessment order. There is no way, in no circumstances, any notices or any orders can be served or passed or given to a chartered accountant. There are cases in context to 148. Where the 148 notice have been given to the chartered accountant merely because he was representing the SSA in some earlier years or in the regular assessment. So the assessing officer, just to comply with the requirement, serves the copy of that notice on the concerned chartered accountant and takes the signature. Thereafter the matter is challenged, and the courts have taken the view that any notice or something has to be served on the SSC and not on the chartered accountant, who is not authorized also for that particular purpose. So what query you have raised, in that case, nor the chartered accountant had any authority. He has merely filed a letter on the instruction of that the most it cannot be taken cognizance. The assessing officer should not have taken cognizance, but that doesn't give him a right or jurisdiction to serve the order on the concerned chartered accountant. In any case, even if you have filed a LA or your authority, it doesn't mean that the order has to be served on you. It has to be served on the concerned SSC.
It's in authority.
Yes.
Most of the time it is mentioned that he has
One. Yeah.
in the authority.
Yeah.
Most of the time you will find that authority to receive a notice
Yes.
is also mentioned.
So in case you have mentioned, so as I said, you are receiving the orders, you are receiving these notices. So if that authority is given, and then then you are liable to your SSC concern. Then you are liable for your SSC. If you have mentioned in your authority that I am entitled to receive the order on behalf, and you receive the order, tomorrow the SSC challenges something. So it is between you and the SSC to take care. So therefore I gave in the beginning that it's a cautious note that you should not accept these types of take an authority to accept the order or receive the order at all. Let them serve the order in accordance with law with the SSC. Even if your LA is there, it doesn't mean that you have to accept it. It doesn't mean that you have to. The assessing officer has to give as per accordance with the law. The LA is given for, or the authority is given for extra purpose. For example, any SSC is not available or he is not there and he wants me to collect the assessment order. In that situation, you should exercise this extraordinary power which has been given by the SSC and not in normal course. Yeah. So that is between the SSC and the chartered accountant. Let's have some legal question, not put some very factual or something personal question where there might be diversion of views. Okay, let's go into the grounds. As I said, there is only 30 days time limit which is there. So you have to be very cautious and draft and file the appeal. Just one second, let me complete this. So the important thing is that within this period you have to draft the grounds of appeal and statement of facts. Now while drafting the grounds of appeal, according to me everyone has their own style, but just I advise that if you are filing a grounds of appeal, many times I have seen some grounds they are mixed together. Everything is jumbled in one. Additions are jumbled, issues of natural justice are jumbled, issues of jurisdictions are jumbled in that, and there is no precise grounds which are raised for each particular item. It will be better if you raise heading wise. For example, you are raising a ground of cross-examination. So you take this ground first. Principle of natural justice is violated. Thereafter you can take the main ground that in the course of the assessment the assessing officer has relied on XYZ document statement and he has not provided the copy of the same, and thereby in spite of specifically asking these things vide letter dated so and so, and therefore the order is violated the principle of nat. So this is something where, and thereafter you can take the case on merits, addition of rupees so and so under section so and so, draft the detailed ground, thereafter you take another addition. So this will give an easy idea while disposing the grounds by the concerned CIT appeals also, and at the later stage also you can very specifically say yes, there was a specific ground in my grounds so and so which dealt with this particular issue. You are challenging reassessment, take a specific ground challenging the reassessment order. The reassessment is bad in law, and why it is bad in law you can take that. So draft your ground very specifically with giving proper headings, numbers. Many times I have seen the grounds are being drafted without even giving numbers. It is in a essay form. So please be specific, be concise. One should, after reading of that ground, should know yes, this is your grievance. Statement of fact, a very crucial document. Time limit is very less, but statement of fact is a very crucial document. I advise that in each appeal you should try to file a statement of fact. If you cannot file a detailed one, at least try to give a basic details what your SSC is, when he has started his business, what business he has engaged, when he had filed the return, when he had received the notices, when he had replied to that notices, what details he had furnished. At least these basic things which are already available with you, at least that much you can feed in your statement of fact. And thereafter, if you find on perusal of your assessment order there are some factual mistakes. For example, he has issued you show cause notice at the fair end and he has not provided you sufficient time for giving the detail. At least mention in your statement of fact that the notice dated 15th March was received by me on 24th March and he has expected me to provide the details mentioned in that on 26th or 27th March. I was not able to comply with that and he passed an order on 30th. So something like that should come in your statement of facts, in your grounds. So all these things, very crucial things, minute things, but it will help you at a later stage in your main appeal. So try to put at least these factual aspects in your matter. If you are not able to put case law, no problem. If you are not able to put your legal arguments, no problem. But the basic facts should always come in your statement of fact. If you have time, you can put some legal arguments also, some rely on some case law also, but at least try to put the basic factual aspects of your matter. Many times it is seen that the assessing officer passes an order without even referring to your letters, your submissions, your details which you have filed. In that situation, it is very necessary that you raise all these points in your statement of fact. This will help you at a later stage. when we are in the tribunal, many times they raise a question, this detail was not filed, where you have filed. At that time, this statement of facts is very crucial to refer. See, I had mentioned in my statement of fact that video letter dated so and so, this detail was filed, but it has not been considered by the assessing officer. Also, if your matter is something of substantial, which you know that ultimately a long drawn litigation will be there, in that situation, statement of facts helps a lot. As the matter goes higher, in tax matters, it changes hands. When the matter reaches at the level of High Court, maybe you are representing up till IT80. When the matter reaches up to High Court, a matter goes to a lawyer. At that time, the statement of facts is very essential. He can read and he can come to know, okay, fine, these are the things what he had filed. These are the things what he had relied and what is wrong with the assessment order. So very crucial document, according to me. Put the basic facts and see that it is filed. Yes.
Statement of facts can be filed on the first day of the hearing.
According to me, it has to be as per the rule, as per the form 35, it has to be filed along with your memo of appeal. What you will be filing on the date of hearing is the submission and not statement of facts. So it is advisable that you file your statement of facts along with your memo of appeal. What you can file subsequently is a written submission. If there is a delay in filing your appeal,
In the statement of facts, needed to give the facts, no documents are to be attached.
according to me, there is no need to
No
put
need of-
any documents. I see many times this document is put. I will come to it. What it is not proper presentation according to me. Some may feel it is proper presentation. I feel it is not a proper presentation, because after 6 months when your matter will come up, at that time you will feel that there is some more document to be filed, something. So it is better to file a separate paper book in the matter rather than including that documents along with the memo of appeal.
Once filed, it can be amended.
Yes, you can amend. You can amend
Before hearing, for example.
at the time of hearing. You can, till before conclusion of your hearing, you can amend. I will come next. Many times while filing, if there is a delay, so you should file a application for condonation of delay. If some factual reasons are there, support the application along with a affidavit narrating briefly why there is a delay in the matter. If there is some delay, don't give flimsy reason. You have seen recently there are few orders of the tribunal where they have passed some strictures stating that this is wrongly stated, or in a very casual manner affidavits have been drafted. See that you give some reason. Don't take the blame on you. Many times I have seen very boldly the chartered accountant say, you can say that the order was misplaced in my office. So don't take these types of plea. Give very specific reason. If it is a case of misplaced, then give some basic reason. The order was received by the SSC on so and so date. It came to our office. Something further, I was not attending the office. There was an article. Give some basic reason, because it may amount to negligence. And if somebody makes a complaint to the Chartered Institute, there will be a clause of case of negligence on the part of the Chartered Accountant. So it is always better when you file this type of affidavit, don't file in a casual or light-hearted manner. Give proper reason. If there is a mistake, accept it that yes, there was a mistake and it was inadvertently not looked into it, something like that. Normally courts are liberal in condoning the delay. So don't make flimsy reasons. Give some genuine reason. If there is a medical reason, somebody was not well or admitted, you can always give a medical certificate. I have seen many times it is merely written, somebody was admitted in the hospital. At the time of hearing the question, who was admitted, in which hospital it was admitted, and then we start supplying the further document. It's very simple. If you are giving a medical reason, mention that family member of so and so was admitted in so and so hospital. The medical certificate or discharge card, etc. is enclosed with. If you are out of station, one line is mentioned, I was out of station. Out of station means where you were. You were in Pune, you were in Nasik, you had gone on pilgrimage, you were attending something else. You can put that so and so SSC was at so and so place. There is no harm, but put the reason. Put that from this day to this day I was so and so place. Why I am pointing out these things? These are very basic things, but why I am pointing out? Because I see time and again the same things are coming, and thereafter we are trying to change and amend those particular reasons. So it is better that you do it at the first stage. Affidavit, if it there, I will give just 1 minute more on affidavit. The affidavit, when you are preparing, see that you give the name, address, the age of that particular person. If he is a director, partner, who karta of a HUF, mention that. You mention that he is aware of the facts and therefore he is entitled to depose in the matter. At the end of the affidavit, you put a verification stating that the above stated paragraphs are true to my knowledge. If there is something which you have heard or borrowed from somebody, then you have to mention that this is the paragraph so and so is, I believe it to be true, and this affidavit has been prepared for the purpose of income tax proceeding. So see that this proper verification is there at the bottom of your affidavit. It is properly notarized also. Notarized, there are two types of notarized, where the SSC doesn't go and where the SSC goes. If your SSC doesn't go, then it is a stamp will be made. You may have to pay some less 50 rupees and he will give you. If the SSC goes, he may charge you and he will make you a entry in a register. When they make an entry in a register, they will put a serial number on the document, and that serial number of the document shows the authenticity of that particular document, that the person had appeared before the concerned notary and signed it. As per the Bombay High Court rule, if any document which is without this serial number, it is not liable to be accepted in the High Court proceeding or anywhere. The same principle applies to everywhere. So see that if you are making such type of affidavit, see that the serial number, it is properly notarized. The SSC appears before the notary, he signs in the register and gets the serial number on the particular document, whether it's affidavit or any other document. See that there is a serial number mentioned in his document. That will be called a proper notary. I have mentioned some decisions on condonation, and the basic principle which have been curled out from these decisions is mentioned. You should try to always highlight that there was no mala fide intention on the part of SSC to make this delay. There was no malpractice which is made by the SSC, and therefore if at all there is some inadvertent mistake which is there, so this should be condoned. In one of the very interesting decision which I have referred, I think so it's the Mumbai Tribunal Earth Metal Electrical, a very beautiful observation is there in this decision, which says that in each and every matter of delay, there is obviously some mistake. There has to be some mistake or some negligence, but that alone you cannot throw away the SSC out of the court. What has to be seen, that whether it is mala fide or not. If it is not mala fide, then what has to be seen? Justice has to be promoted, and the delay whatever has been there, it has to be condoned. So to promote justice, the delay is always required to be condoned. A liberal approach of the courts are there, but only requirement is that it should not be with a mala fide intention. It not be some delaying tactics. Many times appeal is not filed for some delaying tactics, and so that something is there. So all that factors should not be there, and that should be brought out in your application and the affidavit. This is what you should keep in mind by drafting your application. Payment of tax is one of the other requirement, 249(4). This is almost rest. There is no issue in this. If you have not paid the taxes, even at the time of hearing of the CIT appeal, if you pay this admitted tax, your appeal will be admitted and it can be heard. In fact, one step further, there are cases where I have listed here. There are cases where this tax has not been paid, appeals have been dismissed. When the matter is travelled up to the tribunal, before the tribunal the SSC has paid this admitted tax, the tribunal has said that yes, your appeal will revive before the CIT appeal and you can go and re-argue the matter. The only requirement is there that you should also, while paying belated admitted tax, you should also request for condoning the delay. That there was a delay in filing payment of admitted tax. An interesting situation arises, which we can just discuss for 2 minutes, is that in some cases where there are attachments, in such cases there are attachment on the bank account, assets are seized, demat accounts are attached. In that situation, how the SSC is going to pay the tax? In this situation, a very interesting situation had come before us, there where we had requested the department that look, you have seized my demat account, you have seized my bank account. In bank account that much amount was not there. However, my shares were worth more than the admitted tax. So we had made request to the department several times, requesting them that please release some part of the shares, you only sell it and appropriate it towards the admitted tax liability. But the department was not able to do, for the reason there were attachments on that by the CBI also. So the income tax officer felt that who will go to them, ask for them release, and the demat authority, whoever the bank was, said that we will not indulge in this because CBI is there. Who will go to their office? 10 questions will be asked. When the matter reached to the tribunal, we informed the tribunal that this is the situation. The department has the first right. Tomorrow some other authority, SEBI or some other authority will take the money. Ultimately it is a loss to the department, because when all the creditors come and create a charge or lien on that whoever has the right first will be entitled to take away. That it is other separate matter, but whoever will come first, he will be entitled to take away the sum. So once the income tax department has created a charge on that, then he is entitled to sell it off and take that money. So the tribunal directed the concerned commissioner to look into the matter, and thereafter the matter was able to be worked out. Recently also there is a matter of Delhi High Court, it is not referred in my note, 367 ITR 137, page 137, where there was some cash which was seized by the department, and that cash could have been appropriated towards the admitted tax liability, but the department had not done so. SSC had requested for that. When the matter was dismissed on this particular ground that admitted tax was not paid, the court thereafter said that the seized cash is there with you, kindly appropriate towards the admitted tax and see that the appeal is revived. So as per the direction of the court, this particular tax was payable adjusted against the admitted tax, and the appeal was held to be maintainable. So in peculiar situation, this type of situation could also arise. Now coming to further, who will sign the appeal? Primarily the SSC who is there, he has to sign. In case of a company, a person who has signed the return, who is entitled to sign the return, he is to sign the memo of appeal. But there might be a situation where that concerned person is not available or he is out of station. In that situation, what to do? In many times this situation has come. We always see that the next authorized person in the company or in the firm signs the appeal, memo of appeal, gets it filed. There is a defect in your memo of appeal. Subsequently, you can file a revised form 35 before the concerned CIT appeal. The same procedure you can follow it even before the tribunal. In case he is not there, the next authorized person in the company can sign. If there are 3-4 partners, one is the authorized partner to sign the return, the other, if he is not available, let the other partner sign, file your appeal, and subsequently when he comes, you take the signature and file a fresh form 35 or form 36 before the concerned authority. A situation arises many times, it is can an advocate, chartered accountant or authorized representative can sign. It is always advisable not to take this, but a situation is there where it is forced to take, then kindly see that you have appropriate authority for doing it. Don't have a general power of attorney, but take a specific power of attorney from the concerned SSC for signing this particular document. After you have signed it, to make the things proper, look proper, later on whenever the SSC is back, you see that the revised form 35 or form 36 is filed to avoid any this situation. If you have a authority for signing it, any authorized person can sign that particular appeal memo, provided he has a specific authority for doing so. Defect in appeal, somebody questioned that whether we can rectify or amend. Yes, you can do it. There are series of decisions of our own Bombay High Court which allows you to amend the form, amend the grounds. If there is any defect, you can do it. In fact, there was situation where the appeal, many times defects are there and they say it is not maintainable. It is incorrect. If there is a defect in your memo of appeal, the concerned authority should intimate you, look, in your opinion, the verification is not signed, or in your appeal you have not enclosed proper documents, or assessment order is not enclosed, or any other defect is there. They should intimate you and give you an opportunity to rectify that defect. If you don't do it and directly dismiss, it is incorrect. Directly 4-5 Bombay High Court decisions I have referred, you can rely on that. Now after you have done all these things, there comes the question of hearing. When the notice of hearing is received, we should see that we prepare a proper paper book. I have seen many times as we appear before the assessing officer every hearing, because the matter which proceeds before the assessing officer, it is in a different manner. When you are appearing before a CIT appeal, the manner, the proceedings are in a different format. Before the assessing officer, one notice will come, you will go, you will file the details, but this is not so before the CIT appeal. Many times the matter is concluded in one hearing or two hearing. So it is very appropriate that when you go before a CIT appeal, do a proper presentation of your matter, which can be that you prepare a proper paper book which will contain right from your computation, return of income, your annual account, your notices, your replies, the relevant replies and relevant document in support of your claim. And prepare this paper book, put proper index, take the signature if required on the SSC stating that all these documents are on the record of the department, though it is not required, but you can do so. And you can file. Now question arises that sometimes you want to file some extra document, some additional document, some new document. So that you don't merge it with the same paper book. Try to prepare a second paper book, have a continuation number, give an index to that and put your application under Rule 46A why you are filing this additional evidence documents before the CIT appeal. Don't merge everything in one. This is what is the paper book. Now coming to the written submission, you have already filed a statement of fact. The same statement of facts now you have to raise in a form of your legal arguments. You have to take your legal contention. You have to refer your decision in whatever you want to rely. So while you should draft a proper written submission, take whatever points you have. If you have some alternate contention, raise in your in your written submission. If you want to refer and rely on any decision, refer those decision. If it is an unreported decision, try to give a copy of that. If you have some direct decision, it is a reported and it is directly applicable to your case, I will advise that try to take a copy of that decision along with you so that you can, while arguing your matter before explaining your matter to the concerned CIT appeal, it will be very interesting to give him a copy, read along with him whatever you want to say. So do this homework before going to the CIT appeal. A question arises that whether the CIT appeal can dismiss your appeal if you have not appeared by relying what is done by the tribunals many times by relying on decision of multiplan. Answer is no. The CIT appeal has obliged to pass a speaking order based on your grounds and statement of fact. You cannot dismiss your appeal ex parte for non-appearance of the authorized person or the concerned SSA. This is a settled position. In a year, 1 or 2 appeals I find like this, not somebody who has come for the first time does so. Normally nobody does, but sometimes you find these types of things happen. After we go further, additional evidence, there is a Rule 46A. There are circumstances which have been narrated in Rule 46A under which you can file additional evidence. If you want to rely on some additional evidence, please see that this is the first chance and see that you get a chance before the ITAT, but it is very rare. You should always see that this is first and the last chance, and that too you have to fulfill the condition. So be very specific that if you want to rely on some document, see that you get this document. It should not happen later on and you take a plea that he has never asked. If you have your claim, if you want to press something, it is your duty to produce that document. If you have to rely on something, it is your duty to produce that document. For any reason, if you are not able to produce it before the concerned assessing officer, this is an opportunity whereby you can produce those documents. It is very difficult nowadays to get a new evidence admitted at the second level, that is before the ITAT. Also, it is time consuming and waste of money. What will happen if you will produce that document before the ITAT? The ITAT will remand the matter back. So you are back to square one. So it is very essential that if you want to rely on some additional document, additional papers, file it before the CIT. Consider it as a last chance. So file it, prepare a separate application along with this document whereby you will narrate why you are filing this additional evidence, and secondly you will also narrate that why you could not have filed it before the assessing officer. For example, confirmation letters. If sufficient opportunity was not given, sufficient time was not given by the assessing officer, it was at the fag end of the assessment where he had asked you to produce the party, produce the confirmation of the party, you could not have obtained. So this is one of the good reason why you are doing it. Second good reason can be in a case where the assessing officer has passed an order without issuing a show cause notice that I am going to make this particular, and after you receive the order you find that he is saying, then you can say that he has not given me any opportunity, he had never called me, he never issued me a show cause notice, I could not have filed this unless he could have asked me to do that, and therefore it is very essential. The third and very interesting bit is very controversial also, is that many times, which I believe so, which the courts also believe, but this department doesn't believe so. So it is that additional evidence has to be admitted if a justice requires, or if you want to do justice in the matter, then that document should be admitted. If there is a document, by seeing that document, the matter can be changed its color, a decision can be taken. According to me, as an authority, as an appellate authority, they should admit that document. They should see that document. They should not be very technical and saying, no, you have not filed, therefore I will not touch that, I will not see that. No, this approach is incorrect. Additional evidence, what is this rule? This rule is not the end. This rule only states certain circumstances. It is not an exclusive rule. It is not a final that only in these 4 circumstances additional evidence has to be admitted. Additional evidence are also admitted at times by Supreme Court or by the higher courts on when they require that substantial justice has to be done. For some reason it could not have been furnished before the lower authorities, and now it is required to be accepted on the face of it. So even for doing substantial justice, according to me, additional evidence should be admitted. So while you are drafting your application, see all these points, focus all these points, why you are relying on this and why it could not be submitted before the assessing officer. Whenever this particular additional evidence is filed, the procedure, the further procedure is that you have to file it in 2 sets. One set will be forwarded by the concerned CIT appeal to your assessing officer for giving him an opportunity to comment on the additional evidence. This is called a remand, and the assessing officer has to send a report on that, commenting why it should be admitted or whatever his comments is there on that particular document. Considering this remand report, the CIT appeal has to further decide the matter. Why this procedure is there? This is basically a procedure of natural justice. As we raise this plea, that assessing officer is also entitled to see any new evidence is furnished in the particular matter where he has passed a order. So basically this is a rule of provision where a principle of natural justice is required to be followed from the assessing officer's point of view. He should also be given an opportunity to give a comment on that particular document.
So that is only a prescription 46A.
I will come. The 46A has another limb. The fourth limb of 46A says, as I already explained you, I will explain in a different manner now. Rule 46 capital A subclause 4 says about that if as a CIT appeal, I am hearing your matter, you are arguing, you are giving everything, but I feel there is one document, if you will produce, for example some registered document or something further, if you produce, I will be able to apply my mind or take a decision in a better way. So I say, Mr. So and so, kindly in the next hearing produce this particular document, which you had not filed before the assessing officer. So on my instruction, on my direction, you file that particular document. After I receive this document, now what should I do? One is that I will follow the rule, I will send it to the assessing officer, wait for his comment. The second rule can be there that I myself look into it. See it, and thereafter I take a decision. How the courts have dealt it. On page 12, I don't know whether my page numbering and your page numbering, it is not same?
No, not so.
Okay. It is 10. Point number 6.2. I have dealt with this type of situation where the CIT appeals have exercised their powers suo moto, called for the document, considered that document and passed the order. But this rule, some matters are very dangerously used. As I gave you an example, there is some registered document where there is no requirement that I would have given to the assessing officer and he would have his comment on that. I could have decided, decided, no problem. I exercise my power under this particular subclause. But take a case, which many times some CIT appeals do. Voluminous details are filed. For example, let's say confirmation letters. Now if you file this confirmation letter as per the direction of the CIT appeal, tell me how the CIT appeal by merely looking at that confirmation decide your matter. Because whenever a confirmation is filed, some basic inquiries has to be seen. whether the PAN number is correct, where the SSC has been assessed, whether he has the balance sheet, whether he is filing the return, which can only be done if there is some further inquiry made. I have seen many orders where the CIT appeal, out of anxiety, I don't know, for some reason, they were so liberal with the SSC that whatever they filed, they accepted, passed an order in the favor. Matter travelled, department challenged their order, and only on this particular ground, that the basic rule of 46A is violated, that tribunal has set aside the matter back by giving an opportunity to the assessing officer. So you have to be very cautious. This power can be exercised, yes, it can be exercised, but in circumstances. The courts in few decisions have dealt with this, and they have said that where a voluminous details are there, some investigation is required, some inquiry has to be made. In such a situation, the CIT appeal can demand that document from you, suo motu, but he should refer it to the assessing officer for its comment. So it will depend on facts and situation of each case. These are the decisions which you can see. See, I have referred on the same below paragraph 6.3, I have referred a decision where they have said that permission to bring additional document can be granted in exercise of the discretion of the court to achieve ends of justice. According to me, if justice can be done, the document should be admitted, and you should not on technicalities deny the admission of this document. Raising of additional ground, according to me, Supreme Court series of decision, preferably at the time of first hearing you file your additional ground. Additional ground, try to file a separate application stating why you are raising an additional ground and attach the additional ground along with it. Don't mention in your written submission only that I am raising one additional ground. See that you file a separate application for raising your additional ground. The CIT appeal has power to admit this additional ground. According to me, there is no controversy in this, so we will go further. Jurisdiction point, if you have some jurisdictional issue in that, kindly raise that issues before the CIT appeal and which they can look into it. You should also, while this point, you should also consider the new section of 292BB, which says that if regarding service of notice. So if that type of issue is there and if you have not raised before the assessing officer, those cannot be raised before the concerned CIT appeal. But mind it, the issue of service of notice and issue of jurisdiction are two different things. Many times there is a very thin line of distinction which we can draw, that because section 292BB deals only with service of notice. If there is some jurisdictional issue, according to me, you can raise it first time before the appellate authority, in spite that you have never objected it before the assessing officer. So you should raise it. Making a claim for the first time, there was a decision of Ghodes India Supreme Court. Thereafter there is a series of decision, Bombay High Court, Prithvi, brokers and shareholders, which is there, which have raised this issue, and there is no controversy in this. Only from some point of clarification I can make in this is that many times in the course of assessment, if you find that there is a claim, there is an additional claim, or there is something to revise your computation, you cannot file a revised return. The time limit is expired. But at least you can file the revised computation. You can file a separate application stating that I want to raise this particular claim, and pursuant to this claim my revised computation is filed. At least that you can do, so that you will be able to at least comply prima facie the requirements of Ghodes India. Ghodes India says that you should file a return, but according to me, in my earlier lectures when this decision was there, I had explained that this decision has been passed under some misconception, because anytime whenever an assessment is taking place, the time limit for filing the return of income is expired. So probably what the court wanted to say is a revised computation and not the revised, but whatever is there, that is the law that has been subsequently been commented, and the powers of appellate authority is not stopped by this particular decision to entertain any new claim. So if you have any new claim, raise it, file a revised computation affecting that, considering that claim, it should be considered. One more aspect is there, that what you can do apart from filing a revise or going in an appeal. Many times if there is a delay in filing your return, for example if you are claiming ATIB 10 or ATIA 4 deductions, 10A deduction, 10BB deduction, and there is a delay in filing your return. In that situation, you should try to exercise the power given under 1192 by the CBDT. Don't try to take this issue in the appeal, because the power to condone the delay in filing your return is not available to before any authority except the CBDT. So don't mix up these two things. If there is a delay in filing of your return, your claims can be affected. You have to see section 80 AC, which says that if you have not filed your return under section 139(1), then your claims under these section will not be around. There is some other controversy that whether it is 139(1) or 139(4). But that controversy apart, take a safer route. If there is a delay in filing of your return, approach the CBDT, request for condonation of delay. If the CBDT refuses to do, you have a right to file, go in a writ petition against that order. I have referred here some orders, Bombay Mercantile, where it was a bank, cooperative bank, which there was a delay in their audit, because this cooperative bank has to do some special audit through some statutory auditors which are appointed by the cooperative society, and thereafter they have to submit that report. Because that appointment was delayed and the audit report was received delayed, their return was filed late, and there were huge losses which they had claimed in their return, and it was not allowable. They filed an application before under 119 to the CBDT, which they rejected. We filed a writ before the court, and ultimately court granted the relief by condoning the delay. Because while condoning the delay, the same approach is required which I had discussed earlier. So that is much safer route to go. Powers of CIT appeals. Now we can discuss some powers of CIT appeals regarding recovery. Now earlier it was a position that after an assessment order is passed, we have to go to the administrative CIT for calling for the stay of the recovery. The courts, Bombay High Courts, I have referred more than 5, 6, 7 decisions. There is one more you can add in that list. Sierra Realities 368 ITRs, page 366, Bombay. Where the courts have come that the CIT appeals have inherent jurisdiction to consider your stay application, and there is a proper reason also given. See, whenever any authority passes an order and thereafter you challenge it before any particular authority, that particular authority is the best person to decide your stay application, because the appeal is also with him. He can see your appeal memo, he can see the merits of your case, he can consider your case, and thereafter he will be in a position to decide that whether the stay has to be granted, or I can reject the stay and grant you installment, or I can fix a early hearing in the matter, or put any other conditions in that. So he is the best authority to decide the stay application. These series of decisions have held that CIT appeal is the correct authority who has to decide the stay application. One more interesting point, recently I was there in the court, Bombay High Court, and somebody had challenged an order of the assessing officer who had rejected the stay application, and he had filed a writ before the court directly, and he said that my matter is pending before the concerned CIT appeal, but my stay is rejected. The court was first asked that why you are rushing here, you should have gone to the CIT appeal. He said no, this is the practice that we file a stay application. He said this is the practice is wrong. First of all, this very practice that asking a stay to the concerned assessing officer who has passed the impugned order itself is very wrong. He said why you are going to the same officer asking for the stay of his own order. How is that possible? The correct way is that you should go to the concerned CIT or the appellate authority where your appeal is there, and you approach that authority and ask him to decide your stay application, and thereafter you can, if he rejects or something, thereafter you can approach the court. But how you are coming directly so and so. So when the matter was discussed at some level, then he informed, and then he said that please allow me to withdraw my writ and I will exercise my remedy before the CIT appeal. So this was just an observation which was there. So it is always advisable that after within 30 days, within that period of time limit for filing of the appeal is there, you can make a stay application informing the concerned assessing officer that I am in a process of filing the appeal. Do not take a coercive stand till my appeal is filed, because that 30 days time limit is there. Also, you can file your acknowledgement of your appeal if it is there with the concerned assessing officer. But my advice is that thereafter you also file your stay application before the concerned CIT appeal also. And I say there is no harm if we raise this particular point in my grounds of appeal also, that kindly grant me the stay of the alleged demand raised in pursuant to the assessment order, which is the subject matter of appeal. If you put this ground at the bottom of my ground, according to me there is no harm. So you can put this ground also, which will be there at least in your grounds of appeal, and you filed a separate stay application requesting the CIT appeal to consider that on merits. Yes, sir. No, that's what I am saying, that this is mentioning in the grounds is merely I am just saying out of that you can refer in your ground, so that tomorrow some technicalities is there, you can refer that, see, I had mentioned in my ground. But separate application is certainly required. Mentioning in the ground will not suffice. If you want a stay, you file a separate application narrating your facts, what is the merits of the case, what is your financial crisis, how it will be prejudiced to you if the recovery is made against you, how it will affect your business, what is your financial position as of today, and why the stay should be granted. So all these facts should be narrated in your stay application, and it should be filed with the concerned authority. Yes, sir.
So what is the remedy if the CIT himself, jurisdictional CIT, even the Joint Commissioner concerned, doesn't want to act on your application for stay or recovery? Then what is the remedy?
See, as I said that as of today, the powers, as this decision says, that if your appeal is pending before a CIT appeal, if you have filed before the other authority as you name, joint CIT, additional, or whoever is there, my advice is that you file a separate application with the concerned CIT appeals. You can mention in your application that you had filed the similar applications before the other authority which has not acted, and therefore I am approaching you because my appeal is pending, and as per this decision you are the correct authority. You might be you had gone in a wrong forum, but as per this decision the correct authority to decide your stay application is the concerned CIT appeal. So this is the you can file your application and request the CIT appeal to hear your matter. And I don't think so after these series of decisions any CIT appeal will refuse you to entertain your stay application. So this is one thing. Now one interesting point is there. Recently a Delhi tribunal has taken a view that if a CIT appeal rejects your stay application or passes some order, whether that order is appealable or not before the ITAT. There is a decision of Employees Provident Fund Organization, very recent, just few days back it has come. It is available on ITAT online, where the tribunal has held that an appeal can be filed before the tribunal against an order of CIT appeal rejecting the stay application. Sounds very good, very helpful to all this. If he rejects, we can go to the tribunal. But my question is that what can be appealed? An order which is passed under section 250 can be appealed. Can this order which is passed on the my application, whether it is an order passed under section 250, because my appeal or my application which I have filed before the CIT appeal is not under section 246 capital A any of the clauses. It is an application. You can say it is an interim type of relief which has been given in my matter. Whether this appeal will lie to the ITAT, there might be an argument on that, there might be a divergent of view of that, but this is a very interesting and a very beneficial decision which can be used by SSCs, probably because of the correctness of this decision, as a practicality of this decision. Maybe tomorrow the courts will uphold this view, and maybe tomorrow there might be an amendment brought that stay application, because unnecessary what happens, the moment it is rejected, people run in the court, and the court is flooded with these types of matter. And in revenue matters, the courts are very slow in granting you stay. They not 90% of the matters, if you will stay on stay, they only say that the stay application is not properly disposed of, you have not followed KEC guidelines, you have not followed other guidelines, Mahindra and Mahindra. The CIT or the lower authorities is directed back to reconsider your application and pass an order afresh. They are very slow because these are revenue matters. So ultimately revenue has to have, so they are very slow in their approach or in refunding the amounts or something. So they always redirect it to the lower authorities. So this type of proceeding is very interesting and according to me beneficial if it is tomorrow upheld. Yes. Yes, when he has the power to stay, then he has the power to grant installment also. Guidelines, what are the guidelines? I have listed down various decisions. There are more than these other decisions which you can refer. These are some basic decisions which you can refer on the stay application. Very interesting issue was power of enhancement. Very dangerous power. If you are filing an appeal, you should be very cautious that your appeal, you have some substantial point and therefore you have filed. Ad hoc disallowance are there, or so you just don't rush and file an appeal, because remember there is power of enhancement. So what is this power of enhancement? This power of enhancement is that the CIT appeal can issue you a notice and say that look, assessing officer has disallowed say a section 68 some addition of say 50 lakhs, but he says that I want to also consider another item and want to make a disallowance under section 41(1) or something else, any other section. This is which is called power of enhancement. This particular provision of this act has been interpreted by various courts in a very strict manner, because the wording says that the CIT appeal has power to confirm, reduce, enhance or annul the assessment, confirm or cancel or vary the penalty, or may pass such orders as he thinks fit. So the powers given to the CIT appeals are very wide. It has also been said by various courts that these powers are coterminous of that of the assessing officer. The powers of the CIT appeals are therefore very wide. They can do inquiry, they can re-look into the matter, and they can give you an enhancement of the particular addition also. The dispute in this earlier was that whether he can find a new source of income for making an addition, or he can reconsider something which has been considered by the assessing officer and make an addition. Earlier there was a decision of Supreme Court of CIT versus Rai Bahadur 66 ITR, where it was held that the CIT appeal has no jurisdiction to assess a source of income which is not disclosed either in the return of income or in the assessment order. But subsequently there is another Supreme Court decision referred in 224 ITR 610, where it has been held that yes, new source of income if is there, they can find out or they can consider that. So the powers given to the CIT appeal by this particular provision is very wide. It should be exercised therefore very cautiously. If you are going before the CIT appeal, you should know what to say, what to give, where his attention should be drawn. Like in the case of Hawala dealers. Now in many cases I have seen that 10%, 12% addition are there. People are asking, should I go in appeal? I say that the CIT appeal can, from 12 he can do it 25, he can do it 50, or he can do 100. Now you tell whether you want to go or not. So they will say that okay fine, I will think over and I will come back. So you have to think. There might be a CIT appeal who said that why 12? Why not 25? Or he may rely on, by the time your appeal comes, one order comes of some court or some other, maybe the facts are different, but he will say no, I will rely on that, I will make 25%. These are all estimates. If the concerned CIT appeal wants, he will do it, he will give his reasoning and he may do it. So be cautious while going before. See that his attention is like, you can focus him only on the matter which is there. Don't allow him to divert his mind to the other aspect. Control his, which very difficult, but you should try to control him. This is an art which we have to learn by experience. I cannot teach you. It is over the period of experience which I have learned by experience, and certainly others will also do that.
He has got a power to restrict only grounds of, he can take up other issues also.
Yes, certainly. That is what is called enhancement. That is what is called enhancement. Enhancement doesn't mean that the enhancement of that addition which you have challenged. Enhancement is a totally different issue which
is not discussing.
According to me, the powers should be restricted to some way. The reason being that under the income tax, we have different powers given under different provision, and these different powers have been categorized into different authorities. For example, rectification. What is rectification? A mistake. That power is given under section 154 to be exercised by a particular authority. If an assessment order is passed which is erroneous, it's wrong, it's prejudicial to the interest of the revenue, then the powers are given under section 263 to be exercised by a commissioner. If the income has escaped assessment, reasons are there why, how income escapes assessment. The powers are given under 148. The powers are given to the assessing officer. There is no power of review given under the Act to any authority. Now, can all this power be clubbed and given to an appellate authority under 251(1)? Whether he has power to do what 263 a commissioner can do, or he has the power of by doing and saying that yes, income has escaped assessment and therefore I can assess. Whether the power, the wordings of the section, does it mean so? Somebody, tomorrow we can find a judgment which says no, Income Tax Act, separate powers are there. You cannot club everything in 251(1) within that power. That power is an appellate authority. An appeal, a person who is sitting in appeal, a person who sits and appeals something is there, he will see that rise. Why this order is right? What is wrong in this? What is the substance, what is the law in this? What wrong he has done? And why I should give a relief or why I should deny the relief? But this power has been given to saying that it is coterminous with that of the assessing officer. But can he do something which the powers have been given in separate section? Certainly it requires a judicial authority to come with this. Right now decisions are against us. There is I have also referred a decision of Delhi High Court Gurinder Mohan Singh, which says that CITAP has power to consider such item which was considered by the assessing officer and enhance the assessment. If the assessing officer has applied his mind and he has given you a relief, say he has considered and said yes, this is an item which is falling within the head of computer and you should be entitled to 60% depreciation. Now can he reconsider that and say no? If the order is erroneous, there is a power which is given under 263. Let the commissioner exercise that power under 263. How an appellate authority while exercise, but all this argument what I am making is negated because of the decision. So this is merely an argument what I am making. So this is what somebody will have to tomorrow see, that whether this power is really exercising the appellate authority power or it is exercising within 251 all the powers of all the authorities. So this is something, today decisions are against us.
So could it be a matter of fact or could it be a matter of opinion of the CIT? Change of opinion.
It can be anything. Once he has made that, his notice, show cause notice might be an opinion and ultimately it makes an addition that will be a fact. So going further, so it is very wide power. You have to see the only requirement is that he should issue a show cause notice. He cannot do it without issuing you a show cause notice. So you will get an opportunity to rebut that. Another power is that whether the powers of CIT appeal is only in respect of that particular assessment year or he can comment, give direction, finding in respect of any other year. Answer to this is no. The appellate authority exercises jurisdiction in respect of that particular assessee for that particular assessment year. There is one decision which I have not referred in my note, you can take down. It is of Mumbai Tribunal 146 ITD page 553, where it says that the power of appellate authority to give direction to the AO only in regards to the assessee before him, and this power cannot be relayed to a third person whose appeal is not pending before him. So this is the decision of Mumbai Tribunal in the case of Vijay Kumar Sharda 146 ITD 553 Mumbai, which you can refer. As I am on the term of finding and direction, and context to 148, there is very interesting decision which one can read at leisure of Anil Suri, where the ITAT, while disposing of one appeal for one particular assessment year, said that the capital gain doesn't arise in this year but arise in some other year. On that observation, they reopened the assessment and wanted to tax that assessee in that year. The matter travelled up to the tribunal for that other year also, and ultimately the court, relying on the Supreme Court decision of Bhagwan Das 52 ITR, they said that this observation cannot be said to be finding in any manner, because that was not the assessment year involved in that appeal, and it certainly cannot be a direction, because they could not have given such a direction. So it is neither a finding, neither a direction. It was an observation which was required for the purpose of disposing of that particular appeal concern, but that cannot be treated for the purpose of issuing or reopening the assessment for that year. If ITAT also sometimes issue arises, if the ITAT has remanded the matter back on some issues, the assessing officer will pass an order. Thereafter you go before the CIT appeal. At that time, can the CIT appeal enhance? Answer is no. This is a remand proceedings. At that time he cannot enhance. Yes, he can enhance in respect of that particular item, but not in respect of new source, because it is a proceeding after a remand. The assessing officer also cannot do anything above and over and above what the grounds had been set aside. Many times this happens, the assessing officer do this, therefore I am referring this particular point. And I have referred one or two decisions also. With this I have completed the CIT appeals proceedings. Now we will come to the ITAT. In case you have any query on respect of that matter, you can raise. Thereafter we will go to this ITAT. Now ITAT, one should, though it is CGO. Though ITAT is falling within the same building of income tax, but it is not a department of income tax, or it is not related with the income tax. It is an independent authority which was set up somewhere in 1941. In fact, the Income Tax Appellate Tribunal is said to be mother of all the tribunals. The manner, the way it functions, the administrative is best. If you will refer to any or go to any other tribunal in the country, this is one of the finest tribunal in the working, administration, everything, one of the finest tribunal which is there. The powers of this is independent. It has no connection with the income tax authority. It is not an income tax authority for the income tax purpose at all. As of today, the appeals which are pending in ITAT is somewhere around 1,02,000 appeals are pending, out of which around 15 to 18,000 appeals are there within Mumbai, and if you will go to Pune, again there are around 5 to 6,000 appeals which are there in Pune. So if you are there in this region, there are substantial appeal. Youngsters who are there, they can think of entering in this venture in this area. Good prospect is there for the coming years, and considering these types of hawala dealers and these sort of things, more appeals are likely to come. So this is advice to only the youngster, not the others. So the power, so this is what a basic function is there. A new provision has come. If you must have seen the ITAT online, or you must have heard, earlier the ITAT president used to be the highest person, the authority members amongst the existing members, but now there is a change in rule, and it has been said the president of Income Tax Appellate Tribunal can be any person who is a judge of a high court, a chief justice of a court, or the highest judge of the any particular high court. Recently, Mr. Sood has been appointed from Himachal Pradesh High Court as the president of Income Tax Appellate Tribunal. He has taken the charge. Henceforth, only such person will be entitled to appointed as an ITAT president. Going further, time preferring for appeal, there it was 30 days, here it is 60 days. The form is 35, here the form is 36. If we have to file the appeal, can we file an appeal by sending it by registered post? The answer is yes, you can send it by registered post, but you should see that it reaches on time. If there is a delay in the post, decisions are there, but you should avoid it. Only in rare circumstances you should try to exercise this by sending it through post. Whatever I have stated for condoning delay, the same reasons are applicable here, so I will not repeat. Grounds of appeal, statement of fact, except one point. When we are before the ITAT, they prefer to have concise and precise ground. They don't like argumentative, detailed ground. So if you are drafting your grounds of appeal before the ITAT, see that your grounds are concise very specific. See that the figures are mentioned. Many times we mention the grounds that the CIT appeal erred in upholding the addition made by so and so, but of bogus purchases, but they will not refer what is the amount, what is the quantum, and why it has been so. So you have to be your drafting has to be such that within 2 sentences you are able to narrate what is your grievance, and it should not be argumentative. Don't say the further argument, decisions, etc., in your grounds of appeal. There is no requirement of filing statement of facts, because statement of facts is filed before the CIT appeal. Whenever you file an appeal, it should be in triplicate. 3 sets of appeal documents has to be lodged with the ITAT registrar's office, where they will give you an acknowledgement receipt where it will be mentioned the next date of hearing as well as the bench. It will be mentioned immediately, so you will, at the time of filing of your appeal, you will get this particular details where number, your bench and the date of hearing is also known. If there is any change or there is in your address, then you have to file a amended form 36 whenever there is change, intimating the new address, so that the notices, order or any communication is there will be sent to the concerned SSC at the new address. If you have not done so, your appeal might come up for hearing and thereafter it may be dismissed ex parte. So if there is any change, see that you intimate this by filing a revised form 36 before the ITT, because more than 50% of the cases which I see where miscellaneous or ex parte is done is because the change of address is not been intimated to the ITT. Very small thing, procedural thing, but very important. Unnecessary expense and time is wasted. So you can take care of this. Whenever this appeal is filed, 1 set of the appeal goes, 2 sets remains in the ITT, and 1 set is served on the respondent. If we are filed, it is served on the department, the assessing officer. If the department has filed, 1 set is served on us. In an appeal, when the appeal is filed, we have a right to file a cross objection also. Cross objection is filed in form 36 capital A, which has to be filed within 30 days from the date on which you have been intimated or served with the copy of the appeal memo of the other side. So if you have received a department appeal and there are some points which has been decided against you by the concerned CIT appeal, so you can file an appeal in form 36A within 30 days, and that court fees will not be required, and therefore it is very you can take file this cross objection. I can give you an example. You have challenged reassessment proceeding and the addition on merits before the CIT appeal. The CIT appeal decides your reopening against you, and however he decides the merits in your favor. So you are not going to file because ultimately you are benefited. But the department challenges the merits, the addition of merits before the ITT. At that time, you can again take a chance of filing a cross objection by raising the point of reassessment, that the order of reassessment, this particular point decided by the learned CIT appeal is bad in law, and you can file this. This cross objection is also numbered. It will also have, and it has the same sanctity as an appeal. This cross objection and your appeal has to be heard together. It cannot be heard separately. So it has to be heard together. If it is not brought to the knowledge of the ITAT, now it is computerized, automatically it is clubbed. But for any reason it is not done, you should bring it to the attention of the bench. You cannot hear cross objection and the appeal separately. It has to be heard together. If there is any delay, as I said, there is 30 days time from the receipt of the order. If there is any delay in filing the cross objection, the same principles will apply for condoning the delay. I have referred 3 decisions here where there was a delay in filing cross objection. Which is this? Page 17. Page 17. I have referred some few decisions where you can refer that there was a delay in filing of the cross objection, which was condoned by the Mumbai Tribunal as well as by Gujarat High Court. So you can also file a condonation application with the same principle what I have explained earlier. I have referred 1 or 2 decisions also of Delhi Tribunal where they have said a new legal issue can also be raised first time before the ITAT. So if there are some point of jurisdiction is there, so you can raise that in your cross appeal also. There is another point that assuming that you have missed the bus of filing the cross objection also. then what to do? Then there is a rule under the income tax appellate tribunal rules where it says that the respondent has a right to support the order of the CIT appeal on the point which has been decided against him. So for example, this reassessment point which I gave you an example, you have not filed a cross objection. Now what you will do? At the time of hearing you feel that no, there is now a direct decision of Supreme Court on 148 what the CIT appeal had decided. If I will take this ground, only on this ground I will succeed. So what you can do? One is that you file a belated appeal or you file a belated cross objection with application. But if it is too late, the chances of condonation is less. At that time you can file an application under Rule 27. What this Rule 27 says? That respondent has still the right to agitate a point. So if it is taken before the CIT appeals, then that point you can re-agitate before the ITAT. But mind it is not separately numbered. It is not a manner of appeal. You can just re-agitate the point which you had taken before the CIT appeal and it was decided against you. I have referred some case laws here. The old, if you will start from the very old decision of Bombay High Court BR Bhamasi 83 ITR, where it says that power of appellate tribunal are similar to the power of an appellate court under CPC. The respondent in an appeal is entitled to support the decree which is in his favor on any grounds which are available to him. For example, as I said, there might be various grounds on which you can support that order. So that grounds you can raise it by way of Rule 27. There is a controversy, as I said, in cross objection you can raise a new ground altogether, a new claim altogether, but in Rule 27 according to me you cannot take a new plea, totally new plea which you have not raised before the lower authority, or you cannot raise a new claim altogether because it is not in a way of an appeal. It is an application to support the order on any other ground which is available. There are other decisions also of this on this particular point which I have referred in my note. Regarding fees payable, the chart is given. There is no controversy. Only one controversy which many times comes, that if there is an appeal against a penalty order, what is the court fees? The court fees is 500. There was earlier some dispute that it is to be on the basis of the assessed or the penalty amount. Answer is no, it is 500 rupees. There was earlier a special bench decision of Calcutta Tribunal which has been overruled indirectly by Patna High Court in 310 ITR page 195, where they have referred to this decision, and therefore if there is any objection raised by the registrar regarding the fees payable, you can refer to this decision and say that fees payable for an appeal filed on penalty is 500 rupees. Even 263, an order passed by the commissioner under 263, if you have filed an appeal to ITAT, the fees payable is 500 rupees. I have referred one or two decisions on that also. If the CIT appeal has dismissed your appeal only on the limitation ground, so you have filed an appeal before the ITAT only on that ground, you might have not challenged the merits. In that situation also the fees payable will be 500 and not the whole amount. But mind it, this is, according to me, you pay extra court fees but challenge the matter on merits also, though the CIT appeals are not there. Because the power of the CIT appeal, you can always tell if there is a covered issue, if the issue where the Supreme Court is there. In that situation, the ITAT may at times, taking some liberal approach, may condone the delay, at the same time direct the merits of the case also. So there is a chance in some matter. So according to me, pay some extra court fees, challenge both the issues, but you can take a call on that. In case of loss, again the amount is 500 rupees. Monetary limits, it's been revising. Now the monetary limits as per July 2014 instruction number 5 has increased to 4 lakhs, 10 lakhs, 25 lakhs for Supreme Court. The question that always revolves whether it will affect the pending matters or it will affect only to the new matters. Right now the tribunals, few benches are accepting that it will allow, it will be applicable retrospectively to the appeals which have already been filed prior to the date of this notification of this instruction. However, few benches are not accepting that. However, there are various orders which have been come of various tribunals where they are saying that it will apply retrospectively. In respect of the earlier circulars, earlier instruction whereby this monetary limits were prescribed, the courts have already taken a view that it may be applicable retrospectively to the pending appeals. On the same principle, this particular instruction also is being argued to be applied retrospectively. Many decisions are there in favor and few benches are not accepting. Only the limitation is that if there is a repetitive issues, then this circular will not apply. If the issues are of a legal issue, substantial importance, then they can take a plea that it is an issue of substantial importance, therefore this instruction will not. So there are certain exceptions which is mentioned in the circular. If you are not falling in that exemption, you can take benefit of this. While calculating the monetary limits, you don't have to include the interest portion. The issue is that whether surcharge or education cess is to be included. There is no clarity on that. If it is on the borderline, you have to explain that this should be, because what it refers is the tax and not the surcharge and education cess, which is not tax. You can refer to the decision of section 249(4), where it has said that the word is tax, and tax means you have to see the tax alone. You don't have to include interest and other elements. Power of stay has been granted, where you can file a stay petition 500. Just before I am going to this, we have to be very cautious when you are filing. I will tell you a brief procedure. People rush to the ITAT to file stay application. You have to see that whenever you file a stay application, your matter is posted for hearing on Fridays, immediately coming available Friday. So for instance, you file a stay application on Monday, the coming Friday your matter will be posted for hearing. What happens, whether they grant you stay, they grant you installment or reject your stay, you will get a hearing. If it is a stay rejected matter, you will get an early hearing in the matter. If it is a stay granted matter, still you will get an early hearing, because they have to dispose the appeal within 6 months. So in that situation, your appeal is posted for a hearing in advance. You get an early hearing automatically in either of the situation. But in that situation, what you have to keep in mind, your matter will be posted for hearing first. In any bench, it will be posted at the top. It will be high on board. Secondly, even if the bench is not functioning, your matter will be transferred to the other functioning bench. So it will be in no situation that you will have an opportunity of taking adjournment on any ground. Even if you want to, there is no stay, then many times we see the bench, arey yaar, ye bench hai, I don't want to argue before the bench. That option is not available. Whoever is there, you have to argue it. There is no option of seeking adjournment, I am not well, I have to file paper book. All these options are not available. So if you are going for stay, kindly keep all these factors also in mind. Going further, when you file a stay application, you have to see that you calculate your demand, tax demand and interest separately, so that you can impress upon the court that this is the demand and this is the interest. Also specify that what you have already paid. What demand out of the total demand, what amount you have already paid. You have to also specify that what is your current financial position. If you are having financial crisis, by merely making a statement that my financial hardship are there, it will not serve the purpose. You have to explain what is your show, demonstrate that this is the financial hardship which is there. If you are not going to grant me a stay, then I am going to suffer in this particular manner. My business is going to get affected. So all these pleadings should be there in your application, and it should be demonstrated also. Also, at the time of stay application, kindly see that your SSC is present, because you don't know what will happen at the time, whether they will grant you full stay or they will ask you to pay 50%, they will ask you for installment. Whatever has to be paid, it certainly have to be paid by the SSC. So he should be present there to commit that. It should not happen that you commit on behalf of the SSC and later on you have to cut a sorry figure saying no, SSC said who asked you to make that you pay 20% or 10%. So, or he will just say that I don't have money. Then what you will do? So any commitment which is required to be made, see that your SSC is present. He can agree that yes, I am ready to deposit 5 lakhs before so and so date, further amount on so and so date. So it is advisable that your SSC should be present. In case you don't have cash and there is some property or so and so, then you can always give a bank guarantee or you can deposit your title deeds, but it is not advisable always. It is better to give some bank guarantee in some matter. If they are not very insistent that you should have to give something, then try to give a bank guarantee, but try to avoid depositing of title deed because it is very difficult thereafter to get back that title deeds from the department. So these are the few ways when approaching before a stay application. Courts have already, the decisions I have referred, and earlier also I have referred. There is one issue that whether the extension can be granted. Now there are contrary decisions on this point, whether this 180 after expiry of this 180 days, whether extension can be granted, but that Mumbai Tribunal has taken an approach that stay can be extended if an application is made prior to expiry of that stay application, earlier stay granted. So if your earlier stay, your hearing for any reason is not completed within the period of 180 days, you have to apply for extension of your earlier stay which has been granted, whereby the stay will be granted and it will be extended for further period. I have referred some case laws on this, some instructions which are there. You can read it at your leisure, where some principles are there, some useful. You can refer on particular facts or situation. You can use this decision. Regarding regarding hearing of the matter, as I said, the same principle what we have followed before the CIT appeal, prepare a paper book. In the only difference is that in the paper book you have to give a certificate. This certificate is very crucial. Few members of the ITAT, they are very particular about these things. They ask the SSC time and again whether you have, please refer that this document are filed before which authority. You cannot say that this document, the documents annexed in the paper book are filed before the lower authority. This type of statement will not be accepted. You have to specify that documents at serial number 1 to 5 are filed before the assessing officer. Document from serial number 6 to 10 are filed before the CIT appeal. Document at serial number 11, 12 are the assessment order of the subsequent year which are on the record of the department, and therefore I want to rely on the same. So this type of statement, this type of certificate should be there. This certificate should primarily be signed by the SSC. If you are very confident about the document it is filed, then as a chartered accountant, if you have the authority, you can certify them. But it is always advisable to get it certified through the concerned SSC. All the pages has to be certified as true copy. So all the pages has to be signed by the SSC, and thereafter 4 sets of this has to be prepared, 1 for you and 2 for the bench and 1 for the DR, which has to be filed well in advance. At least you try to file 1 week in advance before the tribunal. 2 copies with the bench and 1 copy with the DR. If you don't file it for any reason, the other side can take an adjournment. Same principle as I explained for additional evidence, the same principle has to be applied here. The rule is rule 29. You have to make an application and you have to annex the additional evidence which you have filed before the you want to rely on. File it separately, which will be taken up by the tribunal. Further, if any additional ground, you can raise an additional ground. There is no restriction as raising of the additional ground. Only if there is a new plea, the tribunal might refer the matter back to the assessing officer or the other authority, unless it is a legal plea which can be decided by the tribunal as the facts are already coming out from the record. In that situation, the courts have held that the tribunal should decide the matter there and not should remand the matter back to the assessing officer. Hearing of the matter, there are few types of benches I will explain. There is a SMC bench which is called a single member bench, where the limit earlier was 5 lakhs. Now as per the Finance Act 2015, the limit has increased. There is a division bench where 2 members sit. One is judicial member and one is accountant member. Accountant member is basically a chartered accountant or a member which is a person who has been elevated or taken from the department. So he is called as an accountant member. A judicial member is a person who has taken any judicial post prior to that, or is a lawyer, practicing lawyer, who will be appointed as a judicial member. There is a combination of judicial and accountant member in each bench. However, in SMC, this bifurcation is there because there is a single member. Apart from this division bench, there is a third member bench. The third member bench means that if a division bench on a matter which I am arguing, one member says right, one member say wrong. So both will pass their independent separate orders. This independent separate orders will go to the president, and the president will formulate a question on the difference between the two members, and it will be referred to a third member, and who will hear me on that particular question, and thereafter he will pass an order. He will give his opinion, and on that basis the division bench will again have to pass an order on the basis of the opinion of the third member. This is called third member. There is another which is called a special bench. Special bench is there if there are issues of substantial importance which are going to affect large number of SSCs, or the issues are something where contrary decisions are coming. One bench is taking one decision, one bench is like this present Merlin shipping. Now earlier there were decision against, now because of the Andhra Pradesh High Court decision of Janpriya Andhra Pradesh High Court decision, which says that the decision of special bench is binding in spite of the stay granted by the High Court. Now there are few tribunals which are taking favorable view. One of the decisions of Arcadia which has come. Then there are other decisions which has come which are taking favorable view, that is following special bench. But there are few benches which are not following that particular principle. They say that we are not going to follow Andhra Pradesh High Court, we will follow the other High Court which has said that the decision of Merlin will not be applicable, and they are taking a contrary view in the matter. So in such a situation a special bench can be formulated. Today I was saved from forming a special bench in this type of situation, and I was rescued from the matter. I said that refer in some other matter, not in my matter. Special bench, there are 3-member bench or 5-member bench depending upon the issue which is involved, and that has been heard. Other SSCs are allowed to intervene in the matter. For example, if my matter on this particular issue is fixed, Avinash has a matter on the same issue, he can make an application and he can argue in he can bring his matter also, and he can argue that particular limited issue before the special bench. Normally a special bench is constituted, it is put or notified to all benches, and it is there to the knowledge of every person. So any other SSC can intervene in this particular matter and argue this matter. While hearing, I have already explained, there is from the other side also the DR is present who argues his case. He also has the paperwork, he also has the memo of appeal. He will also argue as you will argue, he has a right to argue the matter. The duty of the bench is to hear both the side and thereafter decide the matter on merits. Regarding the powers of tribunal, the powers of tribunal are wide but not wide enough as a CIT appeal. A person while going to a ITAT will not be worse off by coming in appeal. So whatever addition, disallowance or was sustained by the lower authorities, it cannot be worse off than that. It cannot be more than that. If some relief has been granted by the assessing officer, the ITAT cannot take back that relief. Even if it is patently on the face of it, it is wrong. They cannot take back that relief. They don't have that power. So it is always said that the SSC by coming in appeal before ITAT, they cannot be worse off. They can pass such order on it as they think fit accordingly. Regarding the other, they can also issue appropriate direction in the matter if it is required. If they want some report, they can ask the DR to produce that report in the next hearing. They can call for the records of the party. They have power to commission, they have power to issue commission, or they have power to examine a witness also. They can give an consequential direction in the interest of justice, or they have wide power, but as I said, the powers are not as of the CIT appeal. After the hearing, in some cases, many times some clarification is required or something is required, they can refix the matter also. They have to pass an order within 2 months, or in an appropriate case in 3 months if the situation, so that if the order is not passed within this period, they have to refix the matter and they have to thereafter pass the order. So this is the time limit which is there, which has been fixed pursuant to the Shiv Sagar order of Bombay High Court, wherein the order was passed after 4 months. That matter was challenged before the court, and the court laid down the principle and they directed that there should be a time limit in which the order is passed. After the hearing, they cannot sit independently. Prior to this rule and this order, the order used to be passed after 6 months also. So this is incorrect. As per the Supreme Court guidelines, they have to pass an order within a specified time limit, which now they have specified 2 months, or in certain matters in 3 months. If it is not done so, you can challenge. There is one interesting point in paragraph 8.5 what I have referred, is that revenue cannot be given second innings to improve its case, to make an addition. So if in certain matters if some addition or some wrong inquiry or the incorrect inquiry has been made, you can always take this plea that revenue cannot be given a second innings to improve a case. But at the same time, you should keep in mind that many times we ask for second innings, that please send the matter back, we will comply with the direction, we will produce this or that. Similar type of plea is taken by the department, but you can oppose them by referring to the principles which have been laid down in this decision, that the department cannot be given second innings to improve their case. Power to admit additional ground I have already stated. Power to admit additional evidence, here the rule is a little bit strict. They are very slow in admitting the appeal, admitting any additional evidence. If any additional evidence is admitted at all, they will refer the matter directly to the assessing officer or the CIT appeal. So you are back to square one. So you have to be very cautious, but this is the last stage. I had said there also last, but here is really last. Thereafter in High Court there is no way you can file any additional evidence. When I am talking about additional evidence, you have to keep in mind there are certain documents which are called public documents. Document which is registered, or document which is filed in the court, or it is from the record of the court, an assessment order, these are called public documents. So if you are filing some public document, you are out of the purview of additional evidence. Though it is filed for the first time, it should not be treated strictly as additional evidence. Power of remand, certainly the power of remand is available with the ITAT. They can remand the matter either to the CIT appeals or to the AO with a certain direction depending upon facts and situation of the appeal. Power of enhancement, I have already stated they don't have power. There is a Supreme Court decision of Macrop Global 309 ITR 434 where they have said that tribunal has no power to take back the benefit conferred by the AO or enhance the assessment. The sentence which is normally used here is that an appellant cannot be worse off by filing an appeal before the tribunal. Power to call for documents, I have already stated. Power to award cost, yes, they have power to award cost. Recently one member was there who got retired. He used to, if you want an adjournment or something, he used to impose costs. After some time, people started saying, if you want to adjournment, pay 500 rupees, take an adjournment. They have power to award cost. In many matters, you see where we are SSCs or the departments are unreasonable, they are taking adjournments, or they are not able to argue the matter, not filing the document. They do award cost for condoning the delay also if it is unreasonable, but substantial justice has to be done. They see that the SSC is consistently delaying or so and so, but the matter has some substance, so they award some cost and condone the delay. So they have the power to award cost. There is a decision of Shushila Malge which is available on ITAT online. This decision has been, department has challenged before the High Court also, and it has been dismissed of no substantial question of law. But this decision of tribunal, whether there was a direction of the tribunal and that direction was not followed by the assessing officer. Thereafter there was a second round of litigation, and when it was second round of litigation, the ITAT imposed certain cost on the assessing officer for not following the direction. So certainly they have the power to award cost. There is no power to make protective assessment. Assessing officer can do so, but ITAT will not hold any order on basis of protective assessment as valid. Regarding ex parte order, recently there are few decisions which I have referred in my notes where it has been held on 10.5, where it has been held by Bombay High Court, where it has been held that there is no power of the ITAT to pass an ex parte order. They have to ex parte order dismissing the appeal. They can decide an ex parte matter, but it should be on merits. They cannot reject that. So by relying on multi-plan, they cannot do so. So these are the two decisions. If you are filing a miscellaneous application, refer these two decisions in your miscellaneous application, and thereafter you can proceed. The power to rectify a mistake is a period of 4 years is given from the date of the order. the period is of 4 years. If thereafter you will file, your miscellaneous application will not be entertained. There is a Supreme Court decision also on the same page below of 10.5 I have referred, which is in contest to cess tax, but it should be the principles should apply in the income IT-80 also. In the case of Balaji Steel, where they have said that no power to dismiss the appeal for want of prosecution even if the SSC's counsel has not appeared. If there is now there are provision of 158A which says that if the identical question is raised before the higher forum, you can file an application under 158A and say that the same decision which will be rendered by the higher forum, the same can be applied here. In this situation, what will happen? Your appeal will be kept pending. Whenever that High Court or Supreme Court decision will come, you will not be allowed to argue the matter. The same will be applied here. So where there is a pure question of law, there is no factual and there is no chance of any going here or there. In that situation also, but there are drawbacks and in this. So you should always see, because in income tax you will see that there are amendments. So retrospective amendments, so many times there are favorable amendments also which you can take the benefit also. So in that situation you should be very cautious while filing this, making this application. But there is a provision where you can file an application and say that the same decision should be applied in this year also. Regarding duties of tribunal, they should pass a reasonable order, they should hear you, they should give a reasoned order. These are the basic things which time and again it is incorporated in general law, that they have to pass, they have to hear you, they have to consider the matter, they cannot decide and a matter in a partial manner, they should listen to all the arguments. All these basic duties have been there. Apart from this, one of the interesting few points are there, that if there is a wrong concession of law given by any counsel, whether it will be binding or not. Answer is no, if you are able to demonstrate that the concession of law was given on the wrong presumption of fact, or there was a wrong application of mine, or something was there and therefore it is so, that it is not binding, you can change that maybe in the subsequent manner. In 1 year CIT IT-80 order is recording some incorrect fact, the second year you want to change because saying that this is a wrong concession was given, you need to demonstrate. There are some decision of Supreme Court, Bombay High Court which I have referred, you can rely on that and you can say that wrong concession made by a counsel before a court cannot bind him, the parties, from subsequent matters. Order should be reason speaking, I have already stated. Order should be pronounced in open court. If you will see recently, the IT-80 give a list of the orders which are kept for pronouncement. It is a formality, but it is a requirement which is pursuant to the Delhi High Court order, that any order which is passed should be in an open court. It should not be hidden or it should be known to the parties. That is the basic principle. On that principle, it has been said that the order should be pronounced in the open court. Thereafter, what is the subsequent thereafter is the binding nature of orders. The hierarchy is that I do no need to refer this, I will just orally explain you. What is the hierarchy? The law laid down by Supreme Court is binding the law of the land under Article 141 of the Constitution. Any law laid down by the Supreme Court is binding on all authority. They have to follow that order. They cannot criticize that order. They cannot find exceptions to the order. They cannot try to distinguish this order. Various judgments are there on this point. The lower court should not try to say and comment on the decision of the Supreme Court even if it is wrong. They should accept and follow that. Supreme Court by themselves can change the order by referring to a larger bench, but lower courts cannot overrule that order. As far as coming to a lower authority, High Court, a High Court exercises its jurisdiction over a particular state. For example, Bombay High Court. The Bombay High Court order will be binding on the state of Maharashtra. So all the authorities below the High Court will be, they have to follow the decision of the High Court. They are bound to follow the decision rendered by the High Court, the tribunal, the SCIT appeal and the assessing officer. So if you have some direct decisions are there, there is in your written submission, you can also make one plea by referring to some of these decisions that this is a jurisdictional High Court decision and the same is binding on your honor and the same may be followed. So like that you can make a submission. Similarly, if there is a tribunal decision, the tribunal decision is binding on the CIT appeals and the assessing officer. Between IT-80, now there are different situations, coordinated bench, there is a bench of these 2% and there is a bench of this. They want to take a different view on a manner. When the same type of issue comes, I cannot differ from them. Either I have to follow it, or in case I want to take a different view, I have to refer it to the larger bench and make to the president that saying that there are contrary views, you make a special bench, form a special bench and resolve this issue. But it will be a judicial impropriety and judicial indiscipline if I say no, I will not follow his order, and we both will pass some separate order. It will show conflict of interest between the member which are sitting over the same benches. So this is a requirement of law. To avoid this conflict, a special bench is to be formed and they should not differ. This is what the basic principle of binding precedent which is there, which you can, I have already narrated this. This is the sequence which is made. Similarly, a third member decision is binding over all the tribunals. Coordinate a division bench decision is binding on the same bench, but it may not be binding on the different bench. Different bench means a bench of a different jurisdiction, but not on the same bench. Third member decision is binding over all the benches. Special bench decision is binding over all the benches. They cannot take a, many times there is a conflict between a special bench and the High Court. The High Court will prevail and not the special bench. If the special bench has considered the High Court and thereafter they have passed an order, then the special bench decision will have to be formed. There is, if you go in between this, it will be very, very difficult and to draw a line, because I will go, conflict is always coming there. Now there can be a conflict where there is a special bench decision and there is a High Court, and I am, as a tribunal member, I am in the jurisdiction of High Court. What should I do? Should I follow the High Court decision or here? Conflict views are there. They say no, you are sitting before the High Court. For special bench, anytime it is lower than the High Court, so you have to follow. But the other decision which say no, you see what is the substance, what was the matter before the High Court, what the special bench decided, and thereafter you apply your mind and thereafter you decide. So these types of conflicts are there. This is a very different area which is called as a binding precedent, rule of precedent, which is there. I have narrated some decisions on this which you can refer. Few of these decisions you can refer in your submissions and also file it before the authorities. Coming to miscellaneous application, as I said, there is 4 years time to file a miscellaneous application. A miscellaneous application is filed under 254 subsection 2 of the Income Tax Act before the tribunal. In the miscellaneous application are basically called for two reasons. If there is an ex parte, then you file. If the order contains some mistake which are apparent on record, then you can file. Now mistake, what is mistake apparent on record? There are series of decision on this, but every time there is a conflict, because what is apparent for me may not be apparent for him, or it may not be apparent for him. There are no power of judicial review. You cannot re-argue the matter on the same matter. We cannot re-argue. Mistake means it should be something very obvious, something patent, which somebody can see and say, yes, this is a mistake. A mistake, if it requires to be argued, or some decision is there and it requires to be application of that decision is to be argued, it cannot be said that it is a mistake apparent, or a contention or a point which you had argued but they are somehow dismissed by referring some this and that, and they have dismissed. You cannot say no, my contention was not rightly taken and now you re-hear me and pass. There is no power of judicial review. They cannot review their order, and the only remedy is that you have to go to the High Court by challenging the appeal against that order. So very strict they are while dealing with your miscellaneous application. There was recently a conflict. If you would have seen on ITAT online, there is a decision of Mumbai Tribunal in the case of RW Promotion. What had happened in this? The ITAT had passed the order. Against that order, an appeal was filed in the High Court. However, that order contains certain factual mistake, so a miscellaneous application was also filed. The miscellaneous application, when it came for the hearing, the members asked that whether you have challenged the order. It was informed, yes, it is filed, it is pending for admission. It has not been admitted by the High Court till date. The tribunal refused to hear the miscellaneous application and they passed a small 1 paragraph order saying that just the SSC has already challenged the main order before the High Court, so therefore we cannot look into the miscellaneous application. This order of the tribunal was challenged by us before the Bombay High Court, and recently they have passed the order, but the order it was dictated in the court, and therefore I am aware that they had said that this order is not correct, it is patently wrong. They cannot refuse to entertain the miscellaneous application. They could have entertained the miscellaneous application and decided on merits. They could have said that it is review, there is no mistake apparent on the record, but they cannot refuse to look into my miscellaneous application on the ground that your appeal is pending before the High Court, which is still not admitted. It is the same matter of RW promotion. The order was till before leaving I had checked, it was not on the site. Maybe within few days you will find it on ITT online. So tribunal cannot refuse to look into the matter. In this miscellaneous application, I have prepared a chart whereby I have given some illustration and the corresponding decision I have given. There are more. If I want to add, I can add hundreds more to this. These are some basic points which we come in day-to-day practice. So that I have referred. If there is some direct decisions, there are some points, some crucial material which has not been looked into by the ITAT, your miscellaneous application can be filed. Recently a matter was there of MZL, where a matter was referred to the third member in a penalty proceedings because the tribunal had recorded an incorrect fact. They had confirmed the penalty by recording an incorrect fact that a particular submission was not filed before the assessing officer during the course of the hearing. What had happened, the assessment order was dated say 20th November. My submission was dated 26th November before the assessing officer. Actually, it was in the course of the assessment. The order sheet also noted that, but this was a prima facie mistake. This mistake was accepted at that first hearing. Thereafter, a miscellaneous application was filed. At that time, I was able to get from the chartered accountant the proceeding sheet, wherein on the next page, the assessing officer had recorded this 26/11 noting was done. And along with this proceeding sheet, an affidavit was filed by the concerned chartered accountant stating that yes, he had signed and he had appeared on so and so date. What is the mistake? Is the mistake in the date of the assessment order, which was not corrected for any reason. But this is a mistake which has crept in the order. You have relied on this fact that it was not filed in the course of the assessment proceeding, and thereby you have come to a wrong conclusion that there was a concealment of income and you have confirmed the penalty. There was a difference of opinion on this matter unfortunately, there was difference of opinion between the members. Actually, this is something which it should agree, but because of certain ego reasons or whatever other reason is there, the two members differed in the view, and for this matter, the matter was referred to a third member. The third member ultimately said that if we cannot judge the reasoning, ultimate reasoning, what we have to see here in a miscellaneous application, what is the reasoning, basis of that reasoning. If the basis of that reasoning is wrong, we cannot come to any conclusion that reasoning is correct or not. If the basis of that reasoning was the fact that the submission was not there on the record, so we don't need to judge that particular reason. This is a factual mistake, and if there is a factual mistake, we have to correct it, and the correction can be made by recalling the order. We cannot further judge and say no, if this submission is also excluded, still the penalty can be confirmed. That cannot be a premises. So on that basis, the third member passed the order and the matter was again posted for hearing. So if you are drafting your miscellaneous application, be very precise, see what is the para, what is your paper book, what is the material, what is wrong, and don't try to re-argue the matter, re-agitate the same points again and try to re-argue the matter, because if it is a re-argument of point, it will amount to review and your matter can be dismissed. I have list out the decision. And there are some recent Bombay High Court's order which I have referred in my notes after the chart, wherein they have said that if the tribunal accept that there is a mistake has crept in the order, interest of justice is served if the entire order is recalled and the appeal is reheard. Appeal should not be disposed of in a light-hearted and casual manner. Their observation I have extracted, which you can read, very interesting. If these types of observation you can use while you are arguing your miscellaneous application. Try to be very close to the dispute which is there and refer to those decisions only. There I have listed out various decisions, but those are based on peculiar fact. Don't use any decision anywhere. Try to bring out your case in the parameters of that particular decision and then try to rely on that decision. These are not principles of law in 254.2. What has to be seen, what is the factual mistake which has crept in the order, which has ultimately led to coming to a wrong conclusion. This is what the rectification miscellaneous application is there. With this I am trying to complete my second part also. Thank you very much friends for giving me a patient hearing. Thank you very much.
Thank you, Ajay. You all will appreciate the way he just took up. I think it was, we were thinking earlier that this presentation will require, discussion will require at least 2 or 3 lectures. But in one lecture, though in the extended time, the way he has covered and covered with the practical aspects also, answering to the queries of the members also, and fully almost and an exhaustive material what he has given. Thank you to Mr. Ajay for this, which will be helpful for us as a reference. Oh, as a for the reference book. And before I request for pleasant vote of thanks, a few announcements. Tomorrow there is a lecture meeting by Shri Advocate Vipul Joshi, who will be addressing on difference in transaction value and stamp duty value of immovable properties, covering sections 43CA, 50C, 56 to 7. The meeting is at IMC 4th floor. 25th, Chamber of this Direct Tax Committee has organized a seminar covering on this the new standards which have been notified by this income tax. It's a full day seminar on income competition and disclosure standards. It is on 25th April. It is from 9:30 to 5:30. It is the venue is Mysore Association Auditorium, Baudari Road, Matunga. And very good speakers. Speakers are Nihar Jambusaria, Paresh Wakharia, Sunil Kothare, and Yogesh Thar. Those who are interested may please enroll for SEM. That it is for limited number of members only. So to avoid disappointment, you may please enroll as early as possible. And with this, may I request Mr. Deepesh to propose a very well deserved vote of thanks.
Today, Mr. Ajay Singh has covered entire gamut of representation before CIT appeal and ITAT appeal in exhaustive manner. Also, material is exhaustive. I, on behalf of Chamber, thank Ajay Singh and request you to carry out with loud applause.
One thing I'll point out, see the page number 40, there is Ajay has mentioned the 7 lamps of advocacy. I think you will agree he has all the 7 lamps in that picture. Thank you, Ajay.
So, folks, thank you.